and welcome to the Heart of It All, a podcast about navigating the realities of caregiving. If there's one thing we can all do for our loved ones, it is to have clear directives for our death. Yes, I said the D word. Estate planning is crucial for many reasons, and on today's episode of the Heart of It All, we're going to walk you through it all. You will want to save this episode. I know I learned a ton. Let's get into it. Estate planning. So the Heart of It All is all about helping our loved ones live their best possible lives. We want to be there when they need us, and maybe even, can you imagine, actually anticipating some of those needs before they happen. So there is one definite in all of our lives. Many people don't want to talk about it, but guys, it's our death. We're all going to die. None of us are going to come out of this alive. You know what I'm saying? Anyway, knowing that indisputable fact, we need to have a plan for our death. A plan, a will, some powers of attorney, powers of personal care. A will is one of the most important documents you will ever have in your life. And it's also one of the most thoughtful things you can provide for your loved ones. Today on the Heart of It All, we're going to not only talk about wills, but the all-encompassing term of estate planning. And you don't need an estate, like property, to be planning for your estate. I think it's one of those misnomers that only rich people do these things. Estate planning includes powers of attorney, like I mentioned, and powers of personal care. Some call those a living will, but we're going to break it all down for you today. Our guest is lawyer Jordana Talsky. Jordana was just named to the 2025 Toronto's top lawyers list as nominated by her peers. Jordana draws on her broad experience from Bay Street and boutique firms to her roles as an estate and trust consultant for Scotiabank and independent practitioners to ease the complexities of succession planning and estate administration. She understands that legacy planning and dealing with a loss are weighty issues that deserve professional yet empathetic guidance. It is what it is. C'est la vie, but it can be easier. Recognized in the 2025 edition of the Best Lawyers in Canada and the Best Law Firms, Canada for Trusts and Estates, Jordana's practice centers on probate planning, drafting wills, trusts, and powers of attorney, and providing comprehensive probate and estate administration services. Called to the Ontario Bar in 2010, Jordana holds a law degree from the University of Western Ontario and a Bachelor of Arts in English Literature from McGill University. She has led estate planning workshops, spoken at nonprofits, and taught the estate law bar exam preparation course to international candidates. Jordana is also, I love this so much, a performing musician and a member of SOCAN. Jordana, welcome to the Heart of It All. Thanks so much for being here.
Thank you for having me. Great to be here, Teri.
So I really want to start with just some very basic terminology for folks. What is a will?
A will is a document that sets out your intentions for the distribution of your assets, which can include personal property, real estate, intellectual property, a whole host of things, anything that you own and can dispose of. And it appoints a person or persons to administer your estate after your death.
Okay, a person or persons, and that's called an executor?
Right.
Okay, we're going to get to executor because there's so much terminology in all this. Some of the terminology is new for people, and I think a lot of people get the terminology wrong. So we really are going to break it down for people. I think many people just think that this is where you want your money to go. But what else could you put in a will other than my bank account?
Right, absolutely. You can also include funeral instructions. You can include the distribution of other things of yours that might not be money. You can include instructions for guardianship. So if you have minor children, you want to take into account of who would have custody of those children. And there's some nuances to that, but you can include those instructions in a will. You can also make certain arrangements for beneficiaries if you have incapable or minor beneficiaries or people who need money that you wish to leave to them protected in some fashion. You can design trusts and a whole host of other planning mechanisms in your will.
What about pets? Can you leave pets?
Yes, you can. And I have drafted pet guardianship of pets and also legacies to pets. People can leave money to pets for their care.
Leave money to pets for their care. Is that one of the most interesting scenarios you've come across, or are there just a myriad?
There really are myriad, but it's kind of funny when I left $10,000 to Mr. Bojangles, the caretaker of Mr. Bojangles. But
Mr. Bojangles is coming out just great.
Mr. B's living life, yeah.
So we've got the fundamentals. A will is a document that sets out where you want your money and your belongings and any instructions about your end of life. That's essentially what a will is.
Right.
Okay. We've got some things to break down that will be inside of that will, but I want people to understand right off the bat, what happens if you die and you do not have a will?
It's a really good question. A lot of people think that they don't have to do anything really if there's no will. But the truth is, there's still a lot of administration that needs to be done. There's bank accounts that need to be closed, liquidated and closed. There's arrangements that need to be made. Maybe you got to move your stuff out of a person's home or whatever. And there has to be someone in charge to do that. So really, there still needs to be a process to appoint an executor, which we'd call an administrator if there's no will. And then, in terms of what that executor has the power to do and how to distribute any assets that a deceased person left, it would go according to the law. There is statute law in each province dealing with what we call intestacy. So that's when someone dies without a will. So it doesn't mean that the government necessarily gets it. It doesn't mean that whoever was hanging around gets it. There are laws, and so the laws of intestacy in the jurisdiction in which the person resided would kick in to dictate where those person's assets go.
If you die without a will, then who establishes who the administrator or executor is? Who makes that decision?
Right. So, what needs to happen is someone needs to step forward and apply in the same way that a probate application with a will would be submitted to court to have it verified. You still have to go through that process, but it's more complicated because there isn't a will designating a person. So, the law states there are people who rank in priority who can step forward. By the way, this is Ontario law. I'm speaking about Ontario law. Surviving spouse, and then if not, children, but maybe there's a couple different children that want to do it, so there can be friction, there are lots of problems, but essentially there's a ranking of who may step forward to apply to be the executor or administrator. And you go through the court process of preparing various documents and submitting taxes in some cases to then be appointed as the administrator and have control over the person's assets. And then you have to distribute them in accordance with the laws. So it actually involves usually more legal work and more hands in the pie.
Yeah, I mean, one of the things I said off the top was having a will is one of the most thoughtful things you can do for the people you love. Can you expand on that a little bit, Jordana, in terms of, again, I think that we understand a little bit about what it means if you die without a will, but why is it such a kind gesture to have a will for the people that you love?
Well, you've touched on it. It creates a lot more questions, confusion, and possibly financial implications if you don't have a will because you haven't assigned someone the role and the responsibility of handling your affairs. So either someone that you wouldn't have wanted may be stepping forward, or people might be fighting about who should be stepping forward, people who can't get along, people who didn't know you, people who won't follow your wishes. So there's that end of it. And for the people who are still around, that may create a lot of tension and pain for them, difficulties trying to get things organized and work with that person or just decide on that end. And then there's the legal aspects. You need a lawyer. Well, you should have a lawyer to help you navigate all of the channels in order to get appointed. And there's a lot more to just making the will, I should say. It's also about being organized so that the executor knows what assets you own. So you often don't put the actual asset, you're not putting like bank account numbers unless it's a specific bank account you want to leave to someone. You're often not listing all of that, but as part of estate planning, a lawyer would look at the overview of a person's assets and make sure that the executor is going to know what they're dealing with. So just to circle back, if you don't have a will, there are like maybe no clues about what to do. And of course, also, everyone has a different situation. So the laws of intestacy that dictate where a person's assets go if they don't have a will may not accord with your intentions, and in many cases don't. An example, if you were in a common law a relationship, there are very different rules. A common law spouse is not entitled to the same rights that a married spouse has when it comes to succession laws. So they could be shut out. If you're in a blended family where you have children from a prior marriage and you haven't made proper accommodations, maybe you've done other things during life that the other children don't know about, none of that gets washed out. You really need to be thinking about all these things. And that's why it is a gift for the people that are left, that are living, to be able to manage it efficiently and without added stress.
So, one of the things that you said that I think is a large misnomer, and certainly I was guilty of believing, is that if you die without a will, the government gets it all.
Yeah, I know. So many people ask me that question. So if anyone out there is curious and they want to learn, again, we're talking about Ontario. The statute that governs this area is called the Succession Law Reform Act, and you can actually go in there and read. There's a table that says who gets what if someone dies without a will. And the Crown, the government, is the very last. It's a very end, and it's only if there's no next of kin. So you go through the whole thing if there's a surviving spouse but no kids, if there's a surviving spouse and kids, if there's no surviving spouse, if there's, then there's like parents, siblings, nieces and nephews. I think I flipped around one of those, but it just goes down the list. And then the very end is the government. It's very rare that the government would just come and collect everything.
So, you mentioned that you wouldn't be necessarily writing down specific bank accounts in your will. But what does a person need to gather? What does a person need to have together when they go and make their appointment with a lawyer to create a will?
Well, in my practice, I send out a planning form in advance. There's three sections of information that we want. One is be prepared to talk about the people, the players, the family, the people who we might discuss naming as an executor and beneficiaries. We want to have that discussion. Okay, assets. So categories of assets, like just write down what you own. I have a bank account. I have an RSP. I have a life insurance policy. I've got some fancy artwork. I've got some jewelry. I've got my grandmother in Greece left me money in Greece. Like, you just list it. Okay. And then an estate planning lawyer will be able to funnel that into the appropriate place in a will or tell you what else might need to be done. Also, they'll be asking about, and more in today's world, digital assets. So a lot of us have, websites or royalties being paid where we're in collection rights societies, or PayPal account. All that stuff should be documented somewhere. It's not necessarily going in the will, but you need to be able to direct the executor where to find that. And we have discussions about that. Okay, so that's the second category. Third category is I usually send some general questions to not totally freak people out when we're sitting there, just to start thinking about a few things. Maybe if they're a young couple with minor children, have they thought about where they would like them to live, or have they thought about creating a trust for minors, and like just to sort of get things brewing in the mind, and then we drill down on it in a meeting. So I hope that answers the question.
It does answer the question because I think there is a responsibility of being organized. And that's kind of what this is. It's about being organized about our end of life wishes. That essentially is a will, right? This is what I will to have happen.
Yes. I think a lot of people are, well, they're scared to turn their minds to this, which is, that's fair. Like, that's fair. But what I hope people understand is, you do will, okay, and it's what it is, but you can always change it. You can always change it. You can always modify things. And so it's better to have something in place that you can later finesse and work out. Just to say that people don't always know what to think about it beforehand, or they struggle with some of the questions, and then that creates a roadblock to them doing it. And it's like, no, I have to know everything so I can just do it. So, and no, like, just something is better than nothing. And then you can always tailor it more later.
Are there benchmarks or things that are like, "Oh, I should update my will now?" Or what are those? I know, when my husband and I bought the house that I'm sitting in right now, we created a will then. That was like 20 years ago. Jordana, I think I should make an appointment with you.
Probably. We suggest as a benchmark that you review every 3 to 5 years, because there could be changes in the law that require updates to your documents. But also in your personal circumstances, life events like marriage, death of a party, whether it's like an executor or a beneficiary. If someone's moved away, you might want to discuss that with an estate planning lawyer and how that impacts things. If you have owned a business and you sold the business and there was a change in your assets, if you inherited money, all these touch points are good opportunities to revisit your estate plan to see if there's anything that needs to be adjusted.
I think sometimes people think, eh, estate. I don't have an estate. I don't own anything, or what am I going to leave to people? Somebody can just come and take my shoes and my clothes, and then that's that. Can you clear up that misnomer that, a will or estate planning isn't just for wealthy people?
Absolutely. And I've seen time and time again that it's small estates where there isn't a huge amount of money ends up being the most complicated and the least planned for, and you run into all kinds of problems. So there's still people have bank accounts, okay? Even if all you're getting is CPP and OAS, old age security and Canada pension money to live off of, it's going into a bank account. So most people own a bank account. What else? Your stuff, your personal property. Maybe you collected coins 50 years ago that are worth something. Like I said, intellectual property, maybe, you're an artist and you have royalties somewhere. And then other conventional assets, maybe you have bought a life insurance policy a long time ago, or you have registered accounts or stocks. So people usually do own more than they think. And of course, real estate, if you own property.
Mhm.
Uh, People usually own more than a car, or a nice bike. I don't know.
These bikes can run you these days, Jordana. You are right. Mention the bikes.
Yeah, yeah. So there's stuff.
I'll tell you a story. When my dad died, I had kind of funneled so that he was just using one bank account instead of the two bank accounts that he had to simplify things. And after he died, I didn't think about that other bank account. I did everything that I needed to do at the one bank, and the other bank account, I'm like, oh, he doesn't use it anymore. It's just like nothing's coming in or out. It just is. And then about 6 months after he died, I was looking at his Gmail, just going through. Anyway, there was a notice about like, we owe all this money. And I was like, why do we owe this money? Like, we closed that account. So we go into the bank. I didn't close that account. I just stopped using it. So I was still paying whatever fees were just nominal, and you're paying interest on those fees. It's nominal, but after 6 months, all of a sudden it was whatever. And they're like, no, you have to actually close this account. You have to bring the death certificate in, close the account, and then anyway, they waived some of the fees. They should have waived them all. But that is a case of the business of death.
Ugh. But yeah, it's so true. It's so true. And so at a time when you're grieving the loss of a loved one, it adds so much stress when there's uncertainty and when things haven't been planned for. Even if there's not a lot there, it's still a job that needs to be done. And it makes it easier when you have thought about these things.
So you've used the term executor a few times. What is an executor, and why do you name an executor in your will?
Well, that's one of the components of a valid will, it should name an executor. It's the person who is responsible for administering the estate. So I'll just quickly talk about probate. A lot of people don't understand probate. So,
I don't understand probate.
sure. So, probate is the process of submitting a will to court, or if there's no will, paperwork to court to have it confirmed as the last will, or if there's no will, to have the application confirmed and to confirm that the person named in the will is the true executor. Okay, so you submit all these documents along with the will if you have it. You also pay what we call an estate administration tax or probate tax. And I'll just put that on the side, but you basically submit all this stuff, and then the court confirms it, gives a certificate of appointment of estate trustee to the executor. Let's call that's probate, but that's a fancy name for probate. And then the executor is able to go to financial institutions or what other places where the deceased has assets or has affairs and act. They have the authority at that time to make decisions, to liquidate accounts. And that's what gives them the authority is this certificate. And so probate is the process of getting that certificate.
Okay, so question. When my dad died, my mom was the only executor. We didn't go to court for anything.
Okay, great question.
She just had his death certificate, and she was the only beneficiary and the only executor, and there was no court. So I'm like, my dad's last will and testament did not go to probate.
Great question. Okay. Yes, you're right. So, in certain circumstances, and you've already touched on them, that it was a simple estate and the executor was the sole beneficiary. In certain circumstances, because of how the person's affairs were organized, they may not need probate. So, now it's customary for certain bank accounts or for certain banks to waive probate. They won't need probate if the value of the account is under a certain threshold, but they will usually have the person submit the death certificate and usually a letter of indemnity, which is basically just then taking on liability in the event that this bank account was paid out or closed to the wrong person. But there's paperwork to avoid probate. It's discretionary on the part of the bank or the financial institution. It's not in every case, but that would be an example of where it would be appropriate.
So that's why I get confused about probate. And that's why I think that there are, I think it's really important when we're talking about this, Jordana, to say, yes, there are umbrella laws, and then there are individual circumstances within those umbrella laws. But as a general rule, the process is number one,
Write a will.
then you die and it goes to probate or not. What's the qualification there? And are we trying to not go to probate?
Yes, I would say that it's more seamless to not have to go through probate, and it maintains privacy because a will becomes a public document once it's probated. And of course, you pay probate taxes in respect of a probatable asset, and that would be captured by something going through the probate process. So I'll say, yes, it's usually easier. And yes, you try to waive probate. And how do you do that? Well, when you're making your will, your estate lawyer can advise of how to plan your assets in a way that minimizes the probate taxes. But I'll just add that in some cases you do want to go through probate. It's a little bit nuanced and I don't want to go down that rabbit hole, but depending on dynamics and circumstances, it may be more appropriate to go through probate, or if there's acrimony. But generally speaking, one of the things that you want to do in your estate plan is minimize probate taxes and, if possible, waive probate. So I always have those discussions. That's why it's important for me as the estate planning lawyer to understand the full scope of assets. People are often very private. They don't want to really tell even their lawyer all their stuff. But more than the value, it's the manner of ownership is important because certain assets can be removed or waived from probate.
What are some things that we want for the qualities of an executor?
Great question. I'll just start off by saying a lot of people think that they need to appoint a certain person in their lives because, like, out of respect or some, I don't know, idea. And that is completely false. And I hope to dispel that thought in everyone's mind. Being an executor is a big job and it requires a person who's organized and frankly, like, emotionally capable of handling a lot of different tasks. An executor can and should see an estate administration lawyer to help them, but you want to appoint someone who will be able to handle the responsibilities and also someone who you feel would have faith in carrying out your intentions. Okay, those are two big ones. Location and residence can sometimes be a factor because if an executor is a non resident, then there could be tax implications on the estate. So it depends which residence, but like a US person, no. Not a good idea. That has negative tax implications on the estate. A person in another province, yes, but maybe you'll want to think about appointing two executors if one person's not here and one person could be here. Generally speaking, a person who's resident in the Commonwealth will be fine to appoint, but for convenience and logistics, it may be also a reason to think about appointing someone here as well alongside them.
You kind of hinted at this earlier, but I'm going to ask it directly. Can you have more than one executor?
You can have more than one executor. The caveat is they have to act together. They must act jointly. So you'll want to consider if these people can act well together, if they're appropriate tag team partners, what the benefit would be of having more than one. In some cases, a will may have a majority rules clause if there's disagreement, but it's important to consider who those people are and if they're capable of working together.
I mean, I'm just going to suggest that having more than one executor sounds like a nightmare. What would be so dispel me of the myth. What would be the advantage of having more than one executor?
In my mind, the only advantage would be if there could be disagreement or unclear intentions, and the testator, the person who made the will, wanted a balancing mind in the form of that other person. It's not a great answer because the truth is this should be sorted out and made very clear so that the executor just has to follow what's been laid out. But, family dynamics can come into play. Maybe having this other person will ease the process for another beneficiary or other person involved. These are the kind of things that we discuss when we're going through will plannings. But you're generally right. It is more cumbersome with more than one person. Yeah.
You bring up another interesting point there. Should you be having these conversations with who you are naming in your will for this very important job?
I always strongly advise that. You don't have to. It's not part of the rules or anything, but it's really important to. I always, by the way, always take a backup, because something could happen to that executor. So when I draft a will, I always want to know, okay, just in case something happens to this person before you die, who can we name? It's always a good idea to have the discussion. Maybe the person will learn something about their purported executor that may tip the scales or change their minds. So, yeah, I think it's a really good idea.
Okay, so what is your advice on telling those who are in your will, whether it be children, whether it be friends, other family members, anybody who is named in your will, about what is in that will before you die?
Great question. The best case scenario is being fully transparent with everyone so that executors know, beneficiaries know, everyone know what's going on. And then there's a greater likelihood for there to be a smoother transition and no acrimony. It may not always be appropriate because people's family dynamics are different. Their level of privacy is personal to them. And if there are ne'er do wells in a family, it might not be appropriate to make those disclosures at the risk of the person's financial security or other security. So it really is the kind of thing I would discuss with the client and understand the context.
I think those are really, really good things for people to consider. The context of your relations with friends, family, what expectations are, and how responsible are you in your life to manage the expectations of when you're dead.
As you said, Terry, that's why it's a gift to the people because you're taking on that really that yeah, okay, burden. Hopefully it's less of a burden if you're working with someone that can help you through it. But sure, it's a daunting process to some and so it is a gift that you're giving.
So you brought up digital assets earlier for a website, whatever, but there's also most people these days have a digital footprint, whether it be social media, you can turn social media accounts into remembrance accounts. Are these wishes now part of a will? Do you have these conversations, Jordana?
Yes, we usually include language in the will to authorize an executor to have control over digital assets. And then it usually is a question of the third party app or whatever it is, what their terms of service are about what can be done. So It's usually more general language about who's going to be responsible or in charge of having that authority. In some cases, people want specific wishes for, yes, please make this into a remembrance account or whatever. And you can certainly put those into a will. And in other cases, you might have that as a separate letter of wishes that accompanies the will because things can change, your accounts can change. So you may be advised to keep another document for that. But the discussion will happen, yes, as part of your estate planning.
Can you just write all this stuff on a napkin? Like, does that count?
Yes, you can have that kind of a will. It's called a holographic will. But the hurdles to prove to the court that that's a valid will are greater than if you have a properly written document.
A holographic will is for sure going to probate.
Yes.
You are teaching us exactly what we need to know. Hiring a lawyer, what does that mean when we hire a lawyer for this process?
So there's two components. There's estate planning, and that would be to hire a lawyer to draft your estate planning documents, your will. And we've spoken a little bit about what is involved, the intake process, the kind of information gathering that the lawyer will do, and the questions the lawyer will ask. And then we'll take instructions and formulate the will document, and then execute that will document with the proper legal formalities for it to be a valid will. That's estate planning. And then the other component of what I do is estate administration. When a person dies and there is this will that needs to be dealt with, and there's a probate application process to be submitted to court, a lawyer will prepare that application and also help guide executors, assist them with the various tasks that are involved in administering an estate.
So, can you give us a ballpark of how much it costs if I come to you and I've got nothing and I say, I need a will?
Okay, this is the loaded question. Lawyers charge differently. Some lawyers will charge a flat fee, some lawyers charge an hourly rate. One thing that's important to note is a lawyer's time, you may not understand, layperson may not understand the value because they're getting a document and of how many pages. And behind that is a file to protect the testator. So there's a lot of work that goes into making sure it's a valid will. And also, if it gets challenged down the road, making sure that the lawyer has a proper file. It's a lot of time. They also have all of their years of experience of estate and tax planning that goes into the advice that they dispense. So I'm trying to say that it's hard to put a price on that, and different lawyers with different levels of experience or styles of work will charge different amounts. The other thing I'll mention is I believe it is really important to have a will. Not everybody can afford a customized will that a lawyer will prepare. And I do want to say that estate lawyers are the best to go with. You might deal with other lawyers that will do wills, but I would caution, I would say research your lawyers. But just to go back, I do believe everyone should have a will. Not everyone can afford a lawyer. There are all these online will kits, and I want to mention them because the price points are lower, so they are attractive to many. And I think it's better than not having anything. If you cannot afford a lawyer, then go with that. The caution there is that you're filling it out yourself, and you may make a mistake, and it may not cover off everything that you needed to. There's certain questions that a lawyer who's trained will know to ask that you may not.
Totally fair and totally great answer. And I love it. And I'm so grateful that you bring up the other opportunities for people to still have a will with maybe not using a lawyer. I think that we do need to give people options. And I appreciate your transparency there. You bring up mistakes, you bring up things that people might not know about. What are some of the common mistakes that you've seen when people come in and even talk to you about their will?
Common mistakes. A lot of people don't understand what an executor is or that you need to appoint someone in charge. A lot of people think like the beneficiary is the executor. Some people think that they don't have an estate, and then you have to get their assets, or that if most of their assets are in this one account, that's all they have to put into the will. But there's other language and there's other things that need to go in there, like appointing a non-resident executor, leaving money to minors.
I'm sorry, back up. What's considered a minor under 18?
Yes.
And you can't do that?
If you do that, okay, so if you do that, depending on the sum of money, it may need to be paid into court until they're 18. depending on the sum of money. There are some ways to avoid that with the trustee holding it until they're 18, but that has to be papered properly. And again, it's like nuanced, so you need to be careful.
At what point does a spouse, a marriage, not common law, trump everything else?
That is a very good question. There is a law in their statute law in Ontario that allows a spouse to make an election if they think they haven't been provided for adequately in a will. It would allow them to elect to take an equalization, essentially to treat as though they had been divorced and are splitting their assets if they feel that what they were left in a will is not adequate. There's a time frame within which they have to make this election, but it is there for this kind of a scenario. Also, if there was a prenup signed or a marriage contract signed, that would be something to enforce if there were provisions made in that contract about what was to happen upon death if they were married. So there are some recourses available.
So somebody dies, I've got their will. What do I do with that will? Do I contact a lawyer? Do I take that will to the funeral home? What is the first thing I do with someone's will that falls into my hands after they die?
Good question. Yes, check for any funeral instructions. While they're not binding in a will, they are a place where someone can indicate their wishes. So if you are like someone has just died and you have to handle it and you're an executor, see if there's anything there about funeral instructions, carry them out. Hang on to the will, call the lawyer. The lawyer will, or what I do is I have a whole task list. Here's everything an executor has to do. Take a look at this, start doing what you can, tell me what I'm going to help you with. It's going to involve a lot of different things, securing assets and canceling subscriptions and notifying government agencies and going to the bank. And that's going to involve taking the death certificate and a copy of the will. There's all kinds of steps, different steps for different places. And so a lawyer will be able to direct that person.
Do you have to go to the lawyer who drew up the will?
No, and that's another very good point. A lot of people think that that's the case. No, you don't. One thing I'll note is there's only one original will. So oftentimes people think they have the will, but they have a copy of the will, and the original is with the lawyer, which is a way that the lawyer can sort of stay in the file, and then you call lawyer. I don't do that, but that's a common practice also because lawyers will have fireproof safes, and it's a good place to keep it. But you don't have to visit the same lawyer. As long as you have the original or know where the original is, you can go to any lawyer you want.
Jordana, such a great point. Where should people be keeping their wills?
This is a good question. A lot of people keep it at their lawyer's office because they have the proper facility for it. You can also keep it in a secure place in your own home. I have clients who purchase their own fireproof safe. They want to keep it with themselves. You should not keep it in a safety deposit box. That's a big one. A lot of people think that that's just fine, and it's not. And the reason is while it's a physically secure location, there are obstacles to being able to retrieve it because that asset's going to be frozen and the executor won't be able to get at it until there's something like probate. And then it's chicken and egg because they need the will to get probate. So don't keep it in a safety deposit box. You can also deposit the wills at court in the jurisdiction of your residence. That can sometimes create an extra hurdle because then you have to have the executor retrieve it, but it is an option.
So again, I'll tell you my personal situation because I tell my entire life on this podcast. I have a copy of my mom's will. My brother has a copy of my mom's will. I'm assuming my mom has the original. What does that mean when there are a few copies out there? Is the original not endorsed? What is it?
No, you're on the right track, Stamped. One of the pieces of documentation that is required to accompany a will when it goes to court for probate is an affidavit of execution, and that is usually with the original will. So the affidavit confirms that it was executed validly by two witnesses, and they normally have that with the original will. You could check to see if your mom has that one. You can also check to see if it looks like wet ink. And then you could check to see if what you have is marked as a copy. And you might contact the drafting lawyer and just double check. Usually there's a reporting letter at the end of the file that says, okay, I'm keeping your will or I gave you the will.
Okay, here's what I know. We are having an episode 2 with you because the will process can be complicated. And we've covered a lot of territory here. So before I get into powers of attorney and personal care, I just want to recap wills and probate here for people so they have a takeaway. So let's go through the process. I want to make a will. What do I need?
You need to have mental capacity to make a will, and you need to know your assets.
Give me your top few reasons why everyone should have a will, Jordana.
To make the process of wrapping up your affairs easier and more clear for your survivors.
Is there a financial component if you don't have a will?
Yes, it's more costly to have an executor appointed if you don't have a will. The court process is more complicated. And in some cases, the court may require that person to post a bond.
In your experience, how many wills have to go through probate and how many wills are a simpler process?
Older people, when you're older and you have already lost the spouse and your kids are helping you out, they usually are going to organize your affairs so that you don't need probate. Like you said, like they'll do as much as they can, those kinds of cases. And then like you're drawing down on your account so you don't have a lot of the wealth, and then the bank's going to be able to waive the probate. So those are the cases. Most people do need some form of probate for something. Even for, I have a file now, like even for just canceling the long-term care residence agreement, the company wants to see probate, which we would try to waive, but there's just things that come up where you generally need it.
I'm not the first person to say this, Jordana, but when we're talking about the business of death, and there really is a business associated with death, would you suggest that the will is the most important document?
Yes, alongside power of attorney for property.
Well, that just brings me to next week. That's when we're going to start talking about this because my head's going to explode and I'm going to make an appointment because I need to update my will. Thanks so much for listening to this episode of The Heart of It All. I loved all of that information. Of course, this is a podcast about navigating the realities of caregiving, and our death is part of that. We'd love to hear from you. Do you and your family members have wills? What concerns you about estate planning? How transparent is your family about what your end-of-life wishes are? Follow us on Instagram, Facebook, TikTok, and YouTube at The Heart of It All Pod. If you like the podcast, please subscribe and share this episode with someone who you think could benefit from these conversations. Also, consider giving us a review on Apple Podcasts, Spotify, or wherever you get your podcasts. The podcast was created, executive produced, and is hosted by me, Teri Hart. I couldn't do it without my co-executive producers, Carrie, Hayden, and Jess Carroll of 6 of 1 Digital. Music is provided by Riverside. Thanks so much for tuning in, whatever time of day it is for you, and please always take care. All right, folks. I know that was a lot to digest, and so maybe I should give you like something fluffy to watch after that episode. I'm not going to do that. I'm going to bring you back to 2011 and Alexander Payne's beautiful movie starring George Clooney and a very young Shailene Woodley. It's called The Descendants. It is set in Hawaii. George Clooney's wife has had an accident, and the family is dealing with the aftermath of that accident and a secret. It kind of ties into end-of-life wishes and the decisions that families have to make, and some things about transparency as well. I love this movie. Alexander Payne's The Descendants. It's from 2011. Check it out.